State versus Ryan Tinsley, 17-198, charged with burglary and theft of property. May. Are you Mr. Tinsley?
Yes, sir.
Okay. I've appointed the Public Defender's Office to represent you. And it appears that you're appearing for an arraignment, is that correct?
I can barely hear you.
Okay. You're appearing for an arraignment. How does he plead?
Not guilty, Your Honor.
Okay, we'll enter the plea of not guilty. And we'll have you appear
Do you have an affidavit for this guy?
on May 18th at 8:30 before Judge Webb. Anything else?
There is, Your honor.
Build a house.
Do you think this $5,000 bond appropriate? It's like 15 now.
It's 15.
Yeah, 1,000.
Yeah, 5,000.
Judge, the state has agreed that a $5,000 bond is appropriate in this case as opposed to the one that he currently has. We'll stipulate that at this point.
Very well, that'll be the order of the court.
Thank you, Your honor.
Casey?
Casey Lucas. Your Honor, his father has contacted me, and I met with his father this morning. What he's here for, he's been arrested again after he had bonded out originally for failure to appear. In talking to Dan Brown and to Mr. Lucas, he has a district court case, and he got the dates mixed up, and someone gave him the wrong date, so he did not appear, and that's why the FTA was issued. He did surrender himself last night. The bail bondsman has said that he's already willing to stay on the bond. I've already talked to him.
I'm sorry, when did he surrender himself?
Last night.
Okay.
So what we're asking is to allow him to stay on the same bond, but let him be out, and then we can deal with the case on the FDA, and I think that's been agreed.
Your Honor, if this is a case of a wrong court date, this man's been missing since February the 2nd. He didn't appear in our court in February. This isn't a
Well,
criteria where someone thought he was supposed to be on Thursday and he got here on a Tuesday.
it's a little deeper than that. When they got the cases dismissed or handled in district court, unfortunately, from what I understand, that he thought that was everything. He didn't need to come back. Dumb, but not intentional.
What happened, Mr. Casey?
Yes, sir.
What happened? Why didn't you appear on February 2nd?
My bonds paper said February 2nd, so that was the day I went, and I did not find myself on a docket.
Sir, we called your name on February 2nd. You came into the circuit court courtroom on February 2nd?
Yes, sir.
What time?
It's like 8:30 in the morning.
What do you mean you didn't find yourself on the docket?
I looked at both rooms, and I asked the ladies back on the computers to put my name, and they gave me a date later in February.
Who did you ask? Who did you ask, sir?
I asked both ladies in front of each courtroom with the dockets, and then I went around the outside of the courtroom behind it to ladies with the glass windows and the computers. I asked them as well.
See, that's the problem,
Sure,
Your
I
Honor.
believe all that. But
Your Honor, that's the problem. The woman he's talking about behind the glass window is district court.
Well, Judge, I'd just like to know where he was in the month of March and the month of April and the first 10 days of May. I don't know that that's an excuse. I haven't heard one.
He also had his glass partition in there too.
well, I'll allow it. It needs to appear from now on.
Understand, Your Honor.
That'll be all.
Then he will be released and remain on that bond.
Got an order to that effect, yes.
All right, thank you.
State versus Joshua Callaway, 17-41, robbery, battery, carrying to operation of a vital public facility and theft of property. Good morning.
Judge, I represent Mr. Callaway. I've spoken with the prosecuting attorney this morning, and they have stipulated to a bond of $7,500 in this matter. Mr. Callaway is requesting a lower bond, but we've visited this twice already, and with that stipulation, I think that's an appropriate amount based on what it was, Judge.
Judge, any bond would have a no contact order with it, with the victim or any member of the victim's family.
The allegations here, Judge, stem from an altercation at the Baxter County Jail. He does not know this individual outside of that setting, and certainly won't be contacting him.
Are there any pretrial motions?
No, there aren't today, Judge. We've got full discovery in this matter, and I've spoken with Mr. Callaway several times. Our defense is prepared and we're ready for trial.
Okay. I'll approve the agreed upon bond, no contact with the victim.
Thank you very much, Your Honor.
State versus Brandy Barnes, 17-27. Drugs and firearms, possession of methamphetamine with purpose to deliver, controlled substances, firearms to certain persons, endangering the welfare of a minor. Here for a pretrial.
Judge, that's correct. Mr. Barnes has several other cases pending along with this matter. Today in this matter, there are no pretrial motions. However, we would like to be heard on bond. Mr. Barnes's bond was revoked prior to a previous trial date when I was not here and had a fill-in attorney for me who was less familiar with the case than I am. I've spoken with his bondsman, and I believe that at this point in time they are willing to stay on the $50,000 bond for all of Mr. Barnes' cases that are pending right now. And of course, if not, it's of no issue, but if they are, I believe that that is definitely an appropriate bond based on the fact that while Mr. Barnes does have several charges pending, these are all new charges within the last year, and he does not have prior felony convictions.
I don't find an order where his bond was revoked.
It may not be in that particular file, Judge. He has 3 pending, but his bond has been revoked. We can revisit the issue if you want to look at the rest of the files at the break.
What's the state's position?
The state's position is we arrested Mr. Barnes on January the 10th, 2017 for case 17-27 for simultaneous possession of drugs and firearms, possession of methamphetamine with purpose to deliver, possession of a controlled substance hydrocodone, possession of a firearm by a certain person, endangering the welfare of a minor. Apparently he bonded out of jail on that charge. We arrested him then again in February of this year with theft by receiving a Class D felony. He was allowed to bond out of jail at that time. We arrested him then on March the 1st for simultaneous possession of drugs and firearms, a Class Y felony, possession of firearms by a certain person, possession of a Schedule 6 controlled substance, possession of drug paraphernalia, a number of traffic offenses. That was on March the 1st. We arrested him. He bonded out of jail on that. We arrested him on March 29th for possession of methamphetamine, possession with intent to deliver. Again, possession of a firearm by certain persons, simultaneous possession of drugs and firearms. Your Honor, I don't know how much in bonds this gentleman has made. It's got to be in the thousands of dollars. I don't know how he gets a public defender, but I would like the man to post a $10,000 cash bond and we'll let him out of jail. But making an argument that the only person that he owes money to in the room is willing for him to come out once again so we can arrest him. We've arrested him some 5 times and for it looks like 30 charges to me in the last 3 months is not an argument that the citizens of Baxter County should go up with. So yeah, give him a bond, give him a $10,000 cash bond. You know, he's got to have some skin in the game for him to change his behavior, which he's not going to.
Okay. I'll announce my ruling later. Let me think about it. 16-206 State versus Steve Neisel. Possession of drug paraphernalia, driving on suspended license. It's on looks like this is a revocation.
Judge, on all of the revocations that you'll call today, I did leave applications for all of them with their names on them at the jail, so if they want to apply, we'll represent them.
Okay. You have a lawyer, sir?
No, sir.
Are you going to hire a lawyer?
No.
Are you gonna make application to the public defender?
Yes, sir.
Okay, pick up an application, fill it out, turn it in. I'll have you appear before Judge Webb on May 18th at 8:30 for attorney status and arraignment. State versus Michael Daly, terrorist and threatening, 16-12. You have a lawyer, sir?
No.
Are you going to hire a lawyer or make application to the public defender's office?
I filled out an application for the public defender's office.
You have already filled out one?
Yes.
Okay, do y'all have that?
No, Judge, I was just there. He might have done it after I left the jail this morning. But based on the fact that he's filled one out and he's incarcerated, we can enter his not true plea. We'll send him before Judge Webb. I think that would be his judge.
I'll have you appear before Judge Webb on May 18th at 8:30. That's all we can do today. State versus Amy Corkin, 13-148. Forgery was the original charge. Ma'am, do you have a lawyer?
I filled out a paper for the public defender.
Okay.
Judge, based on that, we will enter our not true plea this morning, Judge. Looks like she's a Judge-led case.
Okay. We'll enter a plea of not true. I'll have you appear before Judge Webb on May 18th at 8:30 a.m.
I have a question.
Yes.
Is there any way to get a bond? They had me on contempt for no bond, or it's failure to pay or whatever, non-payment. And I didn't know if there was a chance of me getting a bond so I could get out. I'm in college and I'm in the middle of finals right now.
Judge,
and I really need to get out to like finish my college.
Judge, I've spoken with
settle this today if possible.
Amy, hold on a second, okay? I've spoken with the prosecuting attorney, and Judge, the restitution amount owed in this matter is just a little over $1,000, and the state will stipulate that $1,000 cash bond is enough to secure her reappearance here.
Very well. $1,000 cash bond.
And then,
Thank you.
I also had a question too. Is there a way to like maybe set up some community service? I mean, I'm a broke college student. I'm just being honest. Like, that's really been my problem.
Hey,
I'm
Amy,
not sitting here trying to, like, pull
Amy,
anything
this is
over.
can you hear me, Amy?
Yes.
Okay, this is something you'll discuss with your probation officer, not the judge, okay?
I'm not on parole anymore. I got off parole over 2 years ago.
Well, they filed a motion to revoke whatever you were on right now, and that's why you're here today. So when you get out, call our office and we'll make sure that you get that set up, okay?
Okay, thank you.
Thank you.
State versus Joseph Smith, 17-61, furnishing prohibited articles, possession of controlled substances, 17-35, methamphetamine, other charges.
Judge, Mr. Smith appears here this morning. I've got frequent contact with him. At this point in time, we're still in plea negotiations. There's no action to take today. We can leave it as scheduled.
Very well. State versus Ashley Wenzel, 17-63, domestic battery, endangering the welfare of a minor.
You and I have spoken with Mr. Etheridge this morning about this matter. We need to continue this case, and we need a reappearance date. The victim's going to appear before you and ask to have this case dismissed. The prosecutor has agreed to take it under advisement for 1 year if she remains in psychiatric counseling. And we've also agreed that the no contact order in this case be amended today. The alleged victim, one of them is her sister, the other is her cousin, and they're having a Mother's Day thing. What they're going to do is they're going to allow her to attend that with and be in contact with them as long as her mother, who is here today, will supervise the visitation. Her name is Teresa Baker.
State going to pursue the case.
It doesn't sound like it.
Well, just present me a proposed order. I'll consider it.
All right, thank you.
State versus Don Hart, 17-37, financial identity fraud and theft by receiver.
Your Honor, on this matter, I've talked to Mr. Etheridge. We received 122 pages of discovery day before yesterday and 3 CDs. We've agreed on this matter that it will be continued, but we ask it not to be reset, and the prosecutors agreed for at least 60 days. She works at Ranger, and they have a 3-strike and you're out program, and she's missed 1 day for today's court, 1 day for illness, so she misses another one in the next 60 days. She's fired. And Mr. Etheridge has agreed to put it out if the court permits for more than 60 days, and so we can get a chance to do our discovery.
Any proposed order?
May she be excused?
Yes. State versus Julie McMeechan, forgery, theft of property, 17-197. Ma'am, I've appointed the public defender's office to represent you.
She's here for arraignment, Judge. If so, we'll waive reading of the information in her plea of not guilty on her behalf.
We'll enter a plea of not guilty, and you and Henry will have her back. August 10th, we have a pretrial on August 10th at
Thank you, Your
10
Honor.
o'clock. 17-189, State versus Dustin Brown, delivery of methamphetamine, drug paraphernalia, possession of methamphetamine, obstructing governmental operations.
We would waive reading of the information, Judge, in her plea of not guilty on his behalf
Okay.
based on our appointment.
Winner of that plea is next appearance is July 20th, 10 o'clock. 17-199, State versus Ashley Dodson, possession of drug paraphernalia. 16-392, possession of methamphetamine, drug paraphernalia. Charge. Who represents you, ma'am?
I think I had a public defender, Mr.
That's correct,
Cooper.
Judge. I'm sorry. Mr. Cooper's her attorney. I apologize. This is a Judge Webb case, and it looks like there was an FTA. I guess she's here to appear before the court to show her face and get back on his scheduling order.
We also have a new case. Who represents her in the new case?
I
Your Honor,
haven't.
with our policy, once she fills out an application, then I'll represent her in that.
Well, I guess you need to fill out an application.
Yes, sir.
And we'll call your case later.
Your Honor, if the court wants to take, is it a first appearance on the new charge?
Yes.
Unless her circumstances have changed, then
Have your
she'll qualify.
circumstances, financial circumstances changed?
No, sir.
I'll appoint the public defender's office to represent you, and we'll enter a plea of not guilty.
Yes, Your Honor.
You want that transferred to the Division 4?
Yes.
Transfer the case to Division 4.
Your Honor, does it show on 16-392 that there is a FTA on her?
Yep. I was wondering that I had my days messed up.
I don't see one.
There's probably not, Judge, because she's not in jail, so usually they're in jail if there's an FTA. Thank you.
Sixteen -377, State versus Butch Holmes, drugs and firearms, possession of marijuana with purpose to deliver, paraphernalia, other controlled substance.
Okay. Judge, I represent Mr. Holmes. He's present today, of course. I believe we have everything. Looks like I've been handed a CD that we haven't had a chance to look at. We have received a plea offer. At this point in time, we're rejecting that plea, Judge,
Very well,
and we'll leave it as scheduled.
very well. 16-327, Ricky Estes, residential burglary, battery. Sir, I'm looking at a police statement. Have you gone over this police statement and conditions of suspension or probation?
Yes, I have.
Did you sign the documents?
Yes, I did.
Do you feel you understand what's set out in these documents?
Yes, I do.
Are you pleading guilty to breaking or entering and battering the third degree?
Yes, sir.
You understand the range of penalties if you're convicted of those charges?
Yes, sir.
Pleading guilty, you give up your right to have a trial and you cannot appeal. Do you understand that?
Yes, sir.
Has anybody threatened you or promised you anything in order to get you to change your plea?
No.
Are you pleading guilty because you pled guilty?
Yes, sir.
What happened here?
On about October 5th of last year, this defendant would have gotten into an argument with his next-door neighbor that escalated until he went into his neighbor's house without being invited and struck him, committing a Class A misdemeanor battery.
I accept your plea. For breaking or entering, you're placed on 5 years probation, or 5 years suspended sentence, rather. For third-degree battery, you're sentenced to 30 days in the county jail. You pay $200 in cost, a fine of $1,000, a DNA fee of $250, $20 booking fee, public defender fee totaling $200. Pay what you owe at the minimum rate of $100 per month, beginning within 60 days. Make your payments to the sheriff's department. Has he done 30 days?
Judge, he's not. He's going to begin that on June 1st by agreement with the state.
That is the agreement, Your Honor. There's a no contact order that will be in effect for the next 5 years for the victim in this matter, any member of his family.
We need to meet with the probation officer before you leave today. 16-315. Jonathan Snow, battery in the first degree, endangering the welfare of a minor in the first degree.
Judge, based on what we've just told the court, there is no action to take today. We'll leave the matter scheduled as of right now.
Very well.
Thank you, Your Honor.
16-93, State versus Jeremiah, Southbridge, rape, incest.
Judge, Mr. Selfridge's matter is first up, I believe, for trial next week, and we are preparing in that matter. I was handed a DVD this morning. I'm not fully aware of what's on the DVD. I don't know if it's game-changing or not, but at this point in time, I have filed a motion that we're requesting that the court take up under 1642-101, more commonly known as the Rape Shield Statute in Arkansas, which requires us to present a proffer of evidence as to whether or not it should be admissible in this matter. I think we could either proffer the evidence by stipulation. I can put on testimony. I'm ready to do that today. The motion was only recently filed on May 8th, and I provided the information to the prosecuting attorney's office that date. I'm not sure if they have any objection to hearing it today. We're ready to move forward with that particular issue. And of course, that has to be determined before the trial, or during the trial, of course. But I think it would be easier on everyone if it was decided beforehand.
Judge, the law requires that hearing to be in camera under, I think it's Rule 24.
Yeah, same rule.
Okay.
I'd like to visit with the judge with that rule so we can figure out the groundwork. We might be able to do it today.
Okay, we'll recall the matter.
Thank you, Your Honor.